For an open manhole accident, can the city be held liable? Stay tuned as we uncover the legal principles behind this landmark case way back in 1958. On the night of January 27, 1958, around 8 p.m., Genaro N. Teotico was waiting for a jeepney at a designated loading zone near the old Luneta and P. Burgos Avenue in Manila. After a few minutes, he flagged down a passing jeepney. As he stepped off the curb to board it, he suddenly plunged into an open, unmarked, and unlit manhole right on the street. The fall was serious. His head struck the rim of the manhole, shattering his eyeglasses and causing glass shards to injure his left eyelid. Bleeding and disoriented, Teotico was rescued by concerned bystanders and rushed to the Philippine General Hospital for treatment. His injuries included a laceration on his eyelid, bruises on multiple parts of his body, and even an allergic reaction to the anti-tetanus shots given at the hospital. Due to the extent of his condition, he had to seek further treatment from a private doctor, which cost him 1,400 pesos. Following the incident, Genaro filed a lawsuit before the Court of First Instance of Manila, seeking damages from the City of Manila and several of its officials, including the mayor, city engineer, health officer, treasurer, and police chief. At the time of the accident, Genaro was not only a practicing public accountant, but also a businessman and professor at the University of the East. He also held key roles in multiple companies and was also active in civic groups. The injuries he sustained forced him to stop working for 20 days, causing him to lose around 50 pesos a day in income. Beyond financial loss, he endured embarrassment among peers and was constantly anxious about the future of his young children, for whom he was the sole provider. He also had to agree to pay his lawyer 2,000 pesos for legal representation. In response, the city's defense presented both documents and witnesses. They claimed that their storm drain section had received a report about the missing manhole cover on January 24, 1958, and immediately covered it the same day. A second report came in on January 30th, after which the cover was again replaced promptly. They insisted that no report was received about the manhole being uncovered during the specific days between January 25th and 29th, the date of the incident. The city engineer's office maintained that it had a policy of acting swiftly upon such reports, either by replacing covers or securing openings with steel matting. They pointed out that rampant theft of metal covers was a problem at the time due to the booming scrap iron trade. To address this, the city had taken steps to redesign catch basins, building them under sidewalks with concrete covers to deter theft, whenever funds allowed. After going through the proper legal process, the Court of First Instance of Manila ruled in favor of the defendants and dismissed Genaro's amended complaint without ordering them to pay any costs. On appeal by Genaro, the Court of Appeals mostly upheld the lower court's ruling. It held the city of Manila liable and ordered it to pay a total of 6,750 pesos in damages. This prompted the city of Manila to bring the case to the Supreme Court. The central issue raised by the city was whether its liability should be assessed under Section 4 of Republic Act No. 409, also known as the Charter of the City of Manila, or under Article 2189 of the Civil Code. RA 409 states that the city cannot be held responsible for injuries caused by the negligence of its officials in carrying out or failing to enforce laws. On the other hand, Article 2189 of the Civil Code provides that cities, provinces, and municipalities are accountable for injuries resulting from defective roads or public structures under their management. Manila argued that RA 409 should apply because it is a special law created specifically for the city, while the Civil Code is a general law that applies nationwide. The Supreme Court ruled that Article 2189 of the Civil Code shall govern. While it's true that Republic Act No. 409, the Charter of the City of Manila, is a special law applicable only to Manila, and the Civil Code is a general law that applies to the entire country, what matters is not just the scope of the law, but the subject it covers. Section 4 of RA 409 outlines a broad rule about the city's liability for damages caused by the failure or negligence of its officials in enforcing laws and ordinances. In contrast, Article 2189 of the Civil Code specifically addresses the liability of local governments, including cities, for injuries caused by defective streets, roads, bridges, and other public infrastructure. Since this case revolves around injuries suffered due to an uncovered and defective road facility, It falls squarely under the more specific provision of Article 2189. Therefore, it rightfully governs the matter at hand. While the city of Manila argued that it should not be held liable for Gennaro's injuries for two reasons. First, that the accident happened on a national highway, and second, that the city was not negligent. The first argument, however, fails because the city never raised the claim that the accident occurred on a national highway during the trial. In fact, Gennaro had clearly stated in both his original and amended complaints that the accident happened on a street under the control and supervision of the city of Manila. In response, the city didn't dispute that. It actually claimed it had kept the streets, including the storm drains and manholes, in good condition and regularly inspected. By doing so, the city effectively admitted that P. Burgos Avenue was under its jurisdiction. The claim that it was a national highway was only brought up later, during the city's motion for reconsideration before the Court of Appeals, which is far too late. Courts generally don't allow parties to raise new factual issues on appeal, especially after a decision has already been made. Regardless of whether P. Burgos Avenue is a national highway, Article 2189 of the Civil Code makes it clear that a city can be held liable for injuries caused by defective roads, as long as it exercises control or supervision over them. Even assuming it's a national highway, the City of Manila still has authority under its charter to manage, inspect, and regulate city streets, including maintenance and public safety. Section 18 of the Charter grants the municipal board extensive powers over streets and public places, covering everything from construction and repairs to regulation of traffic and prevention of hazards. These powers have not been revoked or diminished by later laws, which only relate to highway funding and administrative oversight by the national government. More importantly, the Court of Appeals already found that the City of Manila had control over P. Burgos Avenue and was negligent in its upkeep, both being factual findings. Since appellate courts generally do not disturb findings of fact unless there's a clear error, the Supreme Court upheld the ruling and affirmed the decision ordering the City of Manila to pay damages,